Well, greetings and salutations, everybody. First, I'd like to say to all the people who normally watch my channel, I realize that um, the subject matter, well, it's not every day that I take BS claims and I'm asked to debunk them because some liar put them out on. Oh, wait. Yeah, that is what I do. So that's what my channel has always been about, the stopping of spreading of disinformation and deliberate lies. But anyway, um, how we doing, everybody? So, thank you to all my super secret supporters here, and my fake supporters. I'm sorry. Got to make sure I get them in there as well. Um, so this morning I woke up, and because weather conditions outside were not allowing me to work on my car like I wanted to, I found myself parked behind the computer, and well, I just kind of had an idea about I wanted to check a couple of things because the first thing that was ever brought to my attention had to do with the court documents online about Sean and his eviction. And now I would like to openly say that through my research today, because research does prove people wrong, um, through my research today, one of the things that I've been barking about is that the suit, the actual end fees that were assessed to Sean and his roommate, they didn't match the amount that was needed uh, to say that he didn't pay off his obligation to his lease. Now, through a little bit of research, I did find out that even though you get an eviction, that doesn't remove you from the obligations of your lease, as far as paying them out and various other things that might be in there. Don't believe me? Look it up. Again, look it up. Now, so I would like to retract my initial assessment that the eviction would actually have the amount of money that was owed on the lease as part of that fee. And I'm going to tell you about that here in a minute. But first, I have to take the long way around the village because there's a bunch of information I have to show, and this video is actually going to be much longer than I need it to be. But it's going to be. I just have to make sure that I'm thorough and showing everything that I'm showing because, well, quite honestly, otherwise I have to spend like 2 or 3 days on Twitter and in comment sections on YouTube explaining things to, well, I'm sorry, to Uni and his fans who will buy anything that he says. And I'm sorry if you don't like me saying that, but that's just fact. Because Uni is the source of all of this hoopla, and so therefore Uni is the reason why you are running around with that information. So if you were not his fan, you wouldn't be running around with that information. You'd be a little bit more like me and say, show me the facts. It's pretty simple. Anyway, so let's go ahead and get started so we're not going too long on this. I went on to the Indiana website, that Indiana Courts or courts.in or whatever it was, the website that has the very documents for Sean and his roommate and the eviction. And I got a little curious, and I wanted to see who else had an eviction from Equity Property Management. And not for any other reason than to just for comparison. And like I said, all this information is public. I have the case numbers up here, but I'm not. I have deliberately covered up the last names of people involved. It's not because it's anyway private. It's just the discussion is not about them. So I'm just not even going to make it about them. But just so you can see it, and you can look all these up on that website. Now, what I wanted to make sure that I did in my searches is I wanted to make sure that I restricted it to only people who where Equity Property Management was actually on the ticket there. as being against somebody, and then I also wanted to make sure that I reduced it to Elkhart County. I didn't want to have it statewide. I just wanted it reduced to Elkhart County. The reason for that is because in case there's any kind of ordinances or local laws in that county alone, I wanted to make sure that everybody I'm looking at is on the same playing field before I show some case and but Marion County has this law and this rule and whatever all that would be. So I wanted to keep it all in the same county, and as it turns out, pretty much all the same judge. So let's go ahead and get started here real quick. First, we all know it well. This is Sean's. Okay. And this is the case number and the documents. And I'm only showing the documents that are actually on the thing. Okay. And to make a couple of points. Number one, and this right here. This right here is Uni's big proof. Okay. That no payment was made here. Now he claims, and he's said this enough times, and I'll show you that in a second. He claims that this payment here means that nothing was. Now we already know that Sean was taken by surprise on this and has not taken any action as far as payment to this judgment. I need to make sure that I say that out loud and clear. Okay, we already know that. Okay, but with this zero payment, that's what Uni's going on. So if Sean were to turn around tomorrow and pay off, let's say, this whole thing, Uni would be expecting to see that payment here on this website. Now, I want to make sure that I pointed that out. So, anyway, Sean and his roommate, there was an order of possession that was issued, and then there was a fine associated to the eviction. And that was added with court costs, and this is at the bottom of the page. Pretty simple. Okay, so let's go on to the next one. Now this is somebody named Austin. Austin also had a order of possession, or was denied. They were denied an order of possession, because it says plaintiff advised the defendant has already vacated the apartment, therefore order of possession is not necessary. And I'm going to show you the importance of that here in a second. But he was assessed, and he had $1,700 that he's got to pay. Excuse me. And according to the website, didn't pay a nickel of it. That was all the way back also in 2019. Let's go to the next one. Now we have another one here. This one, there was the order of possession was granted and was given, and they were given 48 hours to after 48 hours they had to move out, and a fine was assessed. The fine was assessed with court costs. Not a dime was paid. Okay. Next one. This was another one. This one, plaintiff appeared, defendant appeared, immediate possession was granted. There was no immediate possession order on the page, but that means that they were booted out of the apartment and evicted, and then assessed $1,425. That $1,425 still says not paid. Okay. Moving on. This one right here, plaintiff appeared, defendant failed to appear, which is, I have found that to be just about almost all of the ones I'm going to show you here. Defendant failed to appear. Possession has already been returned to the plaintiff. Okay, so no order of possession was granted. She was assessed $2,000. Not a nickel was paid, according to the website. Now, let's see. Stephanie here. Plaintiff appeared. Defendant failed to appear. Immediate possession was granted, and the writ was issued. This is the writ right here. 48 hours to get out, or after 48 hours get out, and she was assessed $2,800. not a penny paid. This one, let's just break up the monotony for a second here. The eviction hearing was held. Plaintiff appeared. Defendant failed to appear, but the plaintiff advised that this case can be dismissed without prejudice, which means that there was no case to be had there, and they dismissed it. Okay, no defendant, but still no damages. Next one. Now Yate, he had he didn't appear. Plaintiff advised the court that the defendant has vacated and a writ is not needed. Immediate possession was granted because they weren't certain, and he was assessed $2,200. Not a nickel was paid. Here's another one. Plaintiff appeared. Defendant failed to appear. Default judgment granted to the defendants, or granted against the defendants, similar to what Sean had, and $1,245. Not a penny paid. And I didn't cherry pick these. These were just as they came. You can go look for yourself. I skipped over the ones that were just outright dismissed, with the exception of one or two, just because I wanted to show something. The dismissed ones, or the ones that had absolutely no documentation, I left those out of this. And I stopped looking around. It was like one after Sean's, because after that the COVID regulations started coming in for postponing and pending evictions because of the health crisis. So John here done himself a doozy. Okay, so John, plaintiff appeared. Defendant failed to appear. Immediate possession grant was ordered. The immediate the order of possession was given, but it appears that he made a deal. But both parties failed to appear for the damages hearing. The case is now dismissed without prejudice. However, which sounds like he made a deal with the landlord. You know, hey, I'll get you your money. I'll get you your money. But about 2 months later, he got hit hard. Okay, so that tells me that the deal that he made didn't sit through. So he got hit hard. And so he's got $3,400. Not a penny paid. Okay. Still got more to go. Got another one here. Daphne here. Let's see. Plaintiff appeared. Defendant failed to appear. Immediate possession was granted. And the 48-hour immediate possession order was sent out. Now this one was interesting. Plaintiff appeared. Defendant appeared. Defendant had paid in full, I would guess just prior to the hearing, so it was dismissed. Pretty simple. So there was nothing at the bottom except for a court cost. And that court cost usually falls on the plaintiff. So, one more here. Well, actually, no, I got one or two more here. This one was interesting. Plaintiff appeared. Defendant failed to appear. Return of service indicated that the defendant was not served. Testimony was taken by the plaintiff, indicates that this is the defendant's residence. Immediate possession was granted, and a writ was issued. And then here's the order of possession here, 48 hours, blah blah, and the end bill, $1,831. Not a nickel paid. Okay, these are in 2018, by the way. I need to point that out. We're going back in time here, generally. So, Joseph here. Let's see. Default judgment is now granted against the defendant. It's basically the same thing that Sean had. There was no other documents. $1,200. Not a nickel paid. See how that's working here? Next one. Plaintiff appeared, defendant failed to appear, case was dismissed. Okay. Means that the judge didn't find that Bradley here did anything wrong, or it could have actually been dropped by equity property management. Either way, the case was dismissed, even though the defendant failed to appear. Court costs were assessed, court costs were paid. That is a consistent thing that I've seen on every one of these, is that the court costs were actually paid by equity property management. Let's see. Then just another one, but these I got two here that are kind of interesting. Okay. Eviction was heard. Defendants both appeared in person. Immediate possession was granted, and the writ was ordered. And then there was the 48-hour deal, the 48-hour notice. But a payment plan was actually submitted to the court to pay in installments, and this one actually has a list of payments because these are paid through the clerk. And then here's the funny part. This one actually shows that it's going. Now, last payment was a while back, but nevertheless it shows that it's going, because there is a document filed at the court showing a payment plan. That's showing up to be the minority here, as far as with all the cases that I looked at, having actually a payment plan submitted at the court. Because one thing that it says on the court document, or at the bottom of the court page, is that these are the records of the clerk's office, the county clerk, or the court clerk's office. So if you pay through the court, you're going to see those payments. But most of these things are actually handled outside of the court, and the judgment is actually paid directly to equity property management. Here's another one, same deal. Defendants failed to appear, but there was and there was an immediate possession granted. That means they were still in the apartment, and the immediate possession was given. Now this one was a payment plan, but the payment plan was listed to go to somebody else, not to the court. So the court has no record of any payment. And this will be the last one here. And this is just a standard one that we've seen before. Immediate possession was granted, and on to the damages hearing. Here's the immediate possession. That means that they were still living in the apartment and got the boot. $2,300, not a cent paid through the court. Now, I showed you all that to make one very specific point. Now, let me go ahead and bring up this other thing here. These are all those case numbers. I have them separated into groups now. All the ones where possession was ordered and either denied or listed as not needed, all of those were people who were no longer in the apartment. Okay? That means there was no reason to do that. Now, one thing I also found is that them versus the ones where a order of possession was ordered, it seems to be about a $400 to maybe even $500 difference. So that's probably the reason why they would make the decision not to actually file one of those, to charge even more money, because I'm sure there's some things that are associated with that, some monies that are associated with that, cleaning out the apartment or getting rid of excess furniture that's there, or the police presence that's needed, whatever it might be. Okay, it could be all of those things. It could be, different things. Nevertheless, it seems that as a general rule, the average of the average fees that were assessed to the people who didn't have an order of possession, who had already vacated the apartment, theirs was about $500 less than those who actually did have that order. Now, what that also means is that all of the ones that do have a order of possession, that means all of these people were still in their apartment, or at least believed to still be in their apartment. So, what does that mean? I'll give you the short version of it. The short version of it is, if we go back to Sean's case. Oh, and by the way, I need to note this here. With the exception of that one, there was 0 payments recorded. Okay? 0. Not a cent. That's because of the fact that the only ones that the clerk, the county clerk, would record are the ones that are submitted through the court. There are situations where you are actually managed. Your payments are sent to the court, and the court sends them over to whoever's supposed to get them. All the rest of them have 0. So either there's a ginormous plague in Elkhart County of people who just don't pay their evictions for the last. This went all the way back to 2016, or the 0 basically only means that there was that nobody's paying through. These people are all not paying through the court. Now, one thing that I also did is I cross-checked every one of those cases, the people that were listed in the cases. I cross-checked them with a statewide court set to see, the all Odyssey courts is what it states, which is basically all the courts in the state. And to find out if there was any lawsuits happening afterward, I found none. I also found no lawsuits afterwards for anything else related to it. For the non-payment of the lease agreements, for non-payment of the judgments, nothing. I found 2 possibles, but I couldn't directly correlate them to actually have to do with this. So I just have them as possibles, and I'm not even going to go into them. But there were 2 judgments out there that could have been related, but either the dates or the names didn't 100% match up, or they were just, the cases themselves were pretty nondescript, so you couldn't really find out anyway. So, this is all public information. Anybody who was claiming that a 0 pay, which we know that Sean, again, was not aware of this until very recently, and Sean has also said he hasn't paid anything towards it, at least to the last time that I had heard. However, even if he had, the court record would not show that he had paid it, because his payments would most likely go directly to Equity Property Management, as has the rest of these. Pretty simple, right? I also didn't find anybody who had, I also didn't find anybody who had lapsed, so I didn't find anybody who would actually be in collections to through the Indiana state, any court in Indiana, to find out if any of them were if their credit was going to get hit. Didn't find not one. Doesn't mean they don't exist, just didn't find them on that site, and that's the only place that I know to get them. Okay. I did find a lot of interesting other cases that are related to some of these people. Non-payment of medical bills, various traffic violations. I saw 1 or 2 bank things, and one. And I have to point this out just because I found it so hysterical. One guy here in one of these cases is actually being sued by Yogi Bear, aka Jellystone Park. So, I mean, I'm not even going to go into the case. It's not my song to sing, but hey, man, you do you, all right? So, we got that. So, even if he had paid, and even when he does pay, it's not going to show up on this site. at all. So the argument of a zero being here has nothing to do with his lease agreement, has nothing to do with him not paying out his lease agreement. It only has to do with if he pays this judgment through the clerk's office. That's it. So that was Uni's big proof. Now, there's another thing that he keeps on running. Oh, and by the way, I just have to show you that because that's the first thing that he brought to my attention. He had to show this zero. Okay. A year ago, well, he was talking to somebody else, but he says, a year ago, you gave them $2K right after they didn't pay the landlord. This is his argument. He says this right here means that the landlord was not paid. As I just showed you, this has nothing to do with the landlord or even the payment of this judgment unless a document was filed through the court for paying through the clerk. Okay. Now, one thing that I'd also like to point out, there's a second part to this discussion, and that is also that in this, all of these judgments, to include Sean's, all of these judgments getting the order of possession, that means that somebody was in the apartment or at least presumed in the apartment. Now, we know that Sean had a roommate. And one of the interesting points is that before the eviction was even filed, I would say a good month before it was even filed, Sean was already living somewhere else. We know that for a fact. He was already, snuggled up on the couch with his new squeeze. And so, quite honestly, this means that there was somebody still there. So this eviction, entirely possible, has nothing to do with Sean. Sean was already gone. So whatever caused this eviction to happen, because there was somebody there, has nothing to do with Sean because he was gone. However, Sean's name, at least during that month, his name was still on the lease. So you can add that into your speculation of why he got the eviction in the first place. And please do not forget that the eviction itself, while it is a breach of the lease, does not relieve you of your obligation to the lease as it's so described. Just need to point that out. Now, there's also been quite a bit of talk, which I thought was hysterical. Okay. You see, there is, in the court documents, there is a document of confidential information, which means that ordered by the court, various portions of this entire discussion. Now, some of these ones, they went into some pretty great detail. They actually stated, what the problem was and what happened and all this other stuff. But the ones that didn't had this. That means the information is confidential. And it's usually at the request of the plaintiff or of the defendant. And that's something that's allowed by the judge, and therefore it's reflected in the documents that get released and what doesn't. It's a matter of privacy. It's a matter of confidentiality. Well, one thing that I would like to point out is now this has just been something that bugged me ever since the beginning of this, ever since I got sucked into this by Uni. I just want to point this out. There's always these talks of the lawyer, the landlord, and the property managers. There's all kinds of talks of there was, I called the landlord said he didn't pay. Why was the landlord lying when the donators called then? Okay. There is an email that both confirms no payment and that the image, well, I'm going to get into this one in a minute, and that the image sent to them is indeed Sean Hufford they sued. Absorb that for a second and remember I said that, or actually remember he said that. There is an email that both confirms no payment and that the image sent to them is indeed the Sean Hufford they sued. Because the person wanted to make sure it wasn't a different Sean Hufford. Okay. You never found out an email doesn't exist because it does in fact exist. So that's a lie. La da 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 da. Where is this? The person who emailed the property management and the law firm stated so in chat. Well, it must be true if it was in chat. I mean, come on. It must be true. And then, let's see. It's funny how he says, yeah, and this was another thing. It's funny how he says that if he didn't pay the eviction, it would show up on his credit. Well, that is an interesting point. However, at the time of the quote, that was only a short time after the eviction itself. And that doesn't show up on your credit. An eviction doesn't show up on your credit. If the eviction moves on to a collection agency because you didn't pay it, the collection agency will show up on your credit. But all three of the majors say on their websites that evictions don't show up on your credit. Period. That's just what it is. So deal with that. I don't know what's on his credit report, but the lawyer for the property management informed us that the account had gone to collections. This was 5 days ago. When we asked if they could verify whether or not a payment was made recently. So I'm guessing that it will show up on his credit report soon if it hasn't already. So the lawyer is giving out, according to them, now mind you, it's the lawyer. You could put some quotes around that. The lawyer for the property management. Okay. Notice how nobody mentions any names that they talk to? I wonder why that is. I have a hunch, though. If I go back one slide, it's because of this. The lawyer and equity property management are not supposed to be discussing this even without this. But this could actually get them into even more of a heap of trouble. You see, I think this is funny right here about both confirms no payment and the image sent to them is indeed the Sean Hufford they sued. Well, here's the funny part. If you're writing to the lawyer doesn't even know what Sean looks like, so he wouldn't be able to confirm him anyway. And the people who show up from equity property management wouldn't know who he, to the court at least, wouldn't know who he was anyway. That's an administrative duty. That's it. Okay, so they don't know Sean from a hole in the ground. So why would you need to send a picture to them? Yes, there is another Sean Hufford. Actually, there's another Sean Hufford in Indiana, and all this, but not one that's being evicted from equity property management, so that wouldn't even have been a thing. So the question is, why was a picture of Sean Hufford sent in an email to equity property management or to the lawyer? Why would that be necessary? Well, here's a hunch. I happen to know that when you call up a lawyer asking for information, or when you call up any place asking for information that's considered sensitive or personal information, they want verification of who they're giving it to. So it seems to me that the only reason why you would be sending a picture to equity property management or the lawyer is to try and feign that the person on the phone is actually Sean. Seems pretty right, doesn't it? So the picture that was sent was not so that the lawyer or some clerk from Equity Property Management was trying to verify who they were talking about. Okay, Equity Property Management, I looked all the way back to 2016, ain't evicting another Sean Hufford, so they wouldn't have cared who the hell this other Sean Hufford was in the first place. You sent a picture because you were trying to impersonate Sean to somebody who was not going to give you their information, so you were trying to make it appear like you were him getting more information. See where I'm going with this? That's why you guys keep on saying the property managers and the lawyer and the landlord, is because of the fact that you're full of shit. Pretty easy to surmise, isn't it? So, let's see, what else did I have? Did I have anything else here of value? Oh, yeah, by the way, you need a new hobby, Uni, because if you're going to get mad at other people for having fundraisers, just because yours sucks, and you've had this same note up there since at least last year, so I don't know why you need $1,255 a month for a $4,000 computer. And apparently the people who are trusting Reds, Sean, and the whole rest of the crew, all the people that you like to shoot on, if they're trusting them to help people out and they're very public about the help that they receive, you can't get mad at that just because your Patreon has only raised $50. So, either way, I don't really care what you do, Uni, but if you're going to spread lies about people, man, you need to do a better job. And by the way, I should let you know, to further confirm what I was saying about the lawyer and EPM, I wrote both of them. I did not call them. I'm overseas. I'm sorry. That shit's expensive. But I wrote both of them. And I can happily acknowledge that the lawyer has completely ignored my request for any information, which I even wrote in the email that I'm actually anticipating you not answering this email, because I do know that the privacy laws exist, and everybody else who has come to me in all these stupid comment sections saying to me that, oh man, it's a free country, man, they can just give out all the information they want. Oh yeah? Try and call yours. Have a buddy call yours and see what they get out of them. And Equity Property Management, however, as of today, was very interested in who was walking around saying that there was discussions being had about their personnel apparently releasing confidential or private information, when it even says on their website that they do their very best to make sure that that doesn't happen. So, long story short, I can only conclude that they lied about the contacts that they have made, or whoever they're getting it from. But at the same time, Uni did say that he called them directly, and guess what? Just can't find any way to well, you just can't justify that, because that's one thing that I've been asking for I would say well over a week now. I keep on asking, oh, point me to where the conversation was, point me to the email, point me to this, and nobody's done it yet. And Uni runs every single time I ask, and he sends his little lapdog, Menace to Sobriety, over, and these other idiots, Cyberfunk and all these other putzes, to do his work for him. And but unfortunately, Uni just seems to run away from it every single time. So Uni, quit lying about people, man. Really, quit lying about people when it's this easy to find. And I'm surprised that I was the first one to find this. But as my followers are accustomed to, I'm going to do the legwork. And you know what? If I'm wrong about something, I admit that I'm wrong. I opened this up admitting one part that I was wrong about, thinking that the judgments were supposed to have the lease agreement payments in them. Obviously, you can say that they're not, because all of these judgments were specific. If you looked up the addresses and the amount of rent that was on each place, they seem to be holding to their lease agreements on what their evictions would have been, and a little bit higher if they had to get the order of possession. So that's all I got, guys. I mean, let's see. The vice. Ooh, I gotta. Ooh, hold on a second. Hold on a second. Let me put this in the chat. The vice president of equity property is the one who explicitly asked for the link to the video of Hufford talking shit about their business practices. Well, I also understand that recently, according to Unirock, there is apparently equity property management is really mad at Sean because of the fundraiser that he was doing for them. I'm not even sure how that works. But anyway, let's see. Hearing damages back. Yeah, I did catch that, Justin. The part that seems to be part of the blurb that's put in those documents. So whether it was back rent or not, and well, yeah, that's true. But Sean's does not say that. But I also noticed that Sean's documents actually look a little bit different. Like I said, these are all public documents that are issued from the courts. So, we can't say that anybody did anything different. But his does not say anything about back rent, whereas others, I'll bring them up, as others do. For example, cause remains set for trial as to issue damages and or back rent. This was somebody named, funny enough, somebody named Justin. But not all of them say that. So it would be kind of interesting to find out why some of them include that blurb and some don't. But I did find a mild difference in some of these. But this one has the back rent quote in it. This one has the back rent quote in it. This one has the back rent quote in it. And let's see. That one does not. And does not. So it doesn't seem to be very repetitive. It's like some do and some don't have that blurb in it. And Sean's does not. So at least I don't think it does. Hold on. Bring to the front. Because his is actually formatted differently. Let's see. Is there a back rent thing here? Okay, that's the top of it. Came in the hearing, possession, which said affidavit, this. So that failed to appear, evidence, blah, blah, blah. Court ready to examine. Find the plaintiff and evidence being duly advised in the premises. Now finds the plaintiff with reasonable probability is intended to real estate parties. Okay. It is therefore ordered and adjudicated by the court that possession of the premises be known. And let's see here. Nope, be seized. And the plaintiff be put in possession thereof. Sheriff shall remove the defendants and any and all other occupants. And any and all. I gotta sneeze. Sorry about that. Let's see. And any and all personal property from the defendants. And any and all occupants from the premises, should the defendants and other occupants not vacate the property within 48 hours of this service order. It is further ordered that the sheriff of Elkhart County shall serve upon the defendants, blah, blah, blah. Nope. Nowhere in here does it say that. And this is a far more descript one, so I would actually kind of expect it to be in there. So, no, it's not in there. So, again, long story short, Uni's big proof is a big 0. Literally. And it's a 0 that means nothing. It only means that if somebody paid through the court, then there would be numbers registered there. But again, in summation, all of them had a 0, with the exception of, now there was 2 that actually filed for a payment thing in the court. 1 followed up on it, the other one didn't. If there was a payment method that was put in, and then there was a 0, then you can have that discussion. But everybody seems to have a 0 there. So, ladies and gents, that's all I got. No big surprise. Uni lied about the contacts that he made. Uni lied about well, I won't say lied at this point, but Uni is making a big deal out of this stupid 0 when it means nothing in the first place. Because if they're not paying through the court, it's going to be a 0. That's just what it is. There are no further judgments against them, but there are also no further judgments against any of these other folks. Well, one guy actually did go on about half a year later and get evicted again, but that's not related to this. So, that's all I got, ladies and gents. I'm going to need you to imagine the boom because I don't have the audio set up for it. And, sorry, Uni, you're wrong again. And all your little lapdogs you guys can all regroup and come up with whatever you think is going to be the next big proof. Okay? Burden of proof is on you because you're accusing him of fraud. Period. You need to prove that fraud, and you haven't proven it yet. I have outlined every single damn thing to you. And the only thing that I've gotten wrong so far was thinking that the rest of the lease agreement was going to be in the eviction claim, which does not seem to follow suit on everybody else's claims. It just doesn't. Simple enough. However, the one that was a little bit high, which you could infer, they actually tacked on the additional rent during the period of the dismissal back to the eviction. One could infer that if there was back rent missing, his stuff would be a lot higher. So, don't know what to tell you, buddy. Nothing that you have said so far to prove him a fraud has stayed up. So, ladies and gents, y'all have yourselves a nice night.